Hi, I'm Todd Harris, and thanks for joining us for another episode of TendingBar. TendingBar is all about the legal profession and the lives of lawyers and big issues in the law. As you know, we got started as a way to encourage my students at Georgetown to think about careers of meaning, careers that make a positive impact on society. But it's more than that. By helping students learn from people who have interesting stories to tell about their legal careers, we've discovered that they are stories that we should all hear, things from which we can take our cues and take a lead in how we can find meaning and purpose in our own careers, whether they be careers in the law or outside the law. But today we are going to talk with a lawyer who has done something important. We're going to celebrate a legal victory today, but as we do that, we're talking about something quite serious. There are today some statutes in a number of states, I think there are 6 remaining now, that are discriminatory laws that are anti-LGBT. In my own home state of Alabama, where I was raised, the 1992 law requires teachers, if they talk about same-sex relationships, only to instruct students that such relationships are outside the norms of society and unacceptable and are to be prosecuted under Alabama statute. Those statutes have long been ruled to be unconstitutional, and so the law is unenforceable, but nonetheless, it remains on the books and remains a taboo subject to talk about in school. There are similar laws in other states. Today, we're going to be talking with my friend, Kevin Hall, who has been involved in a litigation around a similar statute in the state of South Carolina, with some recent good news and developments there that he'll share with us. So I'd like to introduce you to Kevin now. Hey, Kevin, you're online. You're on the air now. Thanks for joining us.
Thank you, Todd. I appreciate it. Glad to join you.
Listen, we have a lot to talk about today, and I really appreciate you joining us because this project you've been involved with recently is very important, not just in the state of South Carolina, but hopefully as precedent elsewhere. But I wonder if first we can just get a little background on you. Tell us, why did you become a lawyer?
Todd, I wish I could tell you there was some grand plan. Truth be told, I'm the son of a professor. I was an international studies major. I was always interested in politics and policy and ideas. I knew when I was an international studies major, I was going to have to probably go to grad school or do something else, really to have a chance in a job market. And really through a process of elimination, I ended up going to law school. It wasn't a passion. It wasn't a calling. It became one. But it was not initially. I went to law school really by default. It was better than getting a job. And when I went, I didn't know what I wanted to do. And candidly, throughout law school, which I didn't really enjoy, I wasn't sure whether I wanted to practice law. I did, and I have thoroughly enjoyed it. So it all worked out great. But that's kind of how I ended up on the journey.
Well, so that's interesting that you say that it wasn't initially a calling but became one. So tell us just a little bit generally about your practice and how you came to be part of that practice.
Yeah, I am a commercial litigator. I represent, mostly large companies in business-to-business disputes, which is intellectually satisfying. It is competitively satisfying. It is there's the thrill of victory. There's lots of reward in those ways. But there is a bit of an emptiness, at least for me, in terms of, I'll pick up your phrase, careers of meaning. This is good. Yeah, I'm good at what I do. Yeah, I do a great job for my client. I make them happy. And that's rewarding. But it's not the same as helping somebody in need or solving a problem or advancing equality for a group of people. And so early in my career, I began becoming involved in a variety of pro bono projects. And they range from helping individuals with individual problems, all kinds of everyday life things. And then as I got older and I began to be more interested in policy and related questions and impact litigation, and ended up taking on a variety of impact cases over the years, including the one that you described as we begin today.
So I think you're being a little bit modest, Kevin. So for those outside North Carolina, they might not be aware that you are sort of a political heavy hitter within the state. You count among your clients some very important politicians. Are you able to tell us about some of those representations?
Yeah, I have made my home on the Republican side of the aisle. I tend to be more comfortable there, often frustrated there, but still more comfortable there. I took a sabbatical in 2002 from my practice for 9 months to help manage Mark Sanford's gubernatorial campaign. Represented and still represent Governor Sanford, then Congressman Sanford. Lyndsey Graham is and has been a client. Tim Scott is and has long been a client. And these are friends as well as clients. Nikki Haley as well. Defended Nikki Haley in a series of ethics proceedings here that were very, very politically motivated, and we successfully defended then Governor Haley against those claims. Also defended Mark Sanford's impeachment. It's a rare thing in American society for a governor to face impeachment, just as it is at the federal level, obviously. But successfully represented Governor Sanford in impeachment proceedings arising out of and after his well-publicized affair. And so I have always tried to take the law to the intersection of public policy and politics. I like that intersection of the law, policy, and politics, and very much enjoy that. And for me at least, I feel like that's the place I can hopefully make the biggest impact, the biggest difference in a positive way.
Well, that's great. And that's important background for our viewers and listeners, I think, because it plays into why you've been just the right person for the project that we're going to talk about. So we're here today to talk about the recent case that you were involved in that was related to a statute in South Carolina that had been on the books since the late 80s, a discriminatory statute, and similar to the Alabama statute I described earlier. Can you tell us just a little bit about the statute, and let's hear about that and its impact? What was the statute? What was the rule in South Carolina?
We had in South Carolina, and still have, a Comprehensive Health Education Act that was enacted in 1988. Throughout the country in the late 80s and early 90s, you saw a lot of change in health education curriculum and statutory authorization in the country. And you had an interesting confluence of a variety of events. You had parts of the country, like the Deep South, where I've been born and raised and live, who historically had been hostile to sex education in a public school setting, becoming acquainted with the idea and recognizing in the context of an HIV/AIDS crisis that maybe sex education in public schools wasn't so bad. So you ended up with a new openness for comprehensive education, including sex education, but you also ended up with some real bias in the statutes. And as you mentioned in your introduction, about 8 states in the country, depending on how you count them and how you categorize the laws, enacted what came to be called no promo homo laws, no promotion of homosexuality. And the idea was, among policymakers and legislators at that time was, well, let's have health education. Let's do the birds and the bees. But for goodness sakes, we're not going to promote homosexuality as if you talk someone into being gay, right? That was apparently the prevailing notion at the time. And so you ended up with these no promo homo laws. Specifically here in South Carolina, our Comprehensive Health Education Act included a provision that said there could be no discussion of same-sex relationships in the context of health instruction, except in the context of the transmission of disease. So you couldn't talk about the birds and the bees. You couldn't talk about anything to do with same-sex relationships unless it had to do with disease transmission. So you can imagine associating loving relationships legally exclusively with one thing, and that is disease transmission. As you described, other states have and had similar statutes. You described the Alabama statutes, which in my view at least is one of the more repugnant of the statutes. Utah had a statute. Arizona had a statute, and then most of the southern states that you might expect to have a statute, most did.
And these all apply to public schools in particular?
Correct.
At every grade level, or in any kind of educational level. Did it apply to colleges as well?
It applied typically in K through 12 education, each state having its own wrinkle and its own timing for delivery of sex education or health education, including sexual content. So little wrinkles here and there, but by and large, we're talking K through 12, public schools, and any education that involved sex or reproductive health.
So I wonder in particular, Kevin, what kind of impact would that have on children in the classrooms, gay or straight? Any of the children in the classroom, if that is the message communicated by the taboo of speaking about same-sex relationships, or the affirmative messages being actually communicated about disease. What impact would that have?
It's a terrible impact, and a demonstrably terrible impact. The stigmatization associated with same-sex relationships or being gay or being LGBTQ more broadly is extraordinary. Imagine this. This is a topic that the elected officials of your state have decided is unworthy of discussion. It is an unmentionable possibility, except to make people know that it could involve the transmission of disease, as of course can any type of sexual relationship. But an incredible stigmatization, and it's compounded because the teacher, who ought to be a source of truth and light in a young person's mind, is forbidden to address a question. So it would go something like this. A young person, if they asked a question about same-sex relationships or safety or health in the context of a same-sex relationship, a teacher, under the penalty of termination, had to say, listen, we're not allowed to talk about that. Johnny, let me refer you back to page 44 of the textbook, and let's continue our discussion there. In other words, absolutely taboo. And that is how most school districts in South Carolina instructed their teachers to deal with these types of questions. Now, if you're Johnny in that classroom, imagine hearing that. It may be a question from a straight kid named Johnny. It may be from a kid who is gay named Johnny, or a kid who's not sure who they are and of their own sexual identity. Imagine in this day and age, 30 years plus removed from 1988, if you're sitting in that classroom and you had same-sex parents. Imagine if you've got a gay brother, a cousin, a sister. It is an incredibly demeaning and stigmatizing statute. That is reflected in states with similar provisions, with much higher suicide rates, much higher rates of bullying among and visited upon LGBTQ students. Gay adolescents and teens, LGBTQ to be more broad, have extraordinarily higher suicide rates than kids of the same age. This is even more so the case in states with no Promo Homo laws that take that historical societal stigmatization, enact it in law, codify it, and then impose it through their education systems like we had here in South Carolina.
Yeah. Well, I don't share a lot of personal information on TendingBar, but as you and I have talked about, this is a personal issue for me. I lost a niece just a few years ago to suicide. She was a wonderful, brilliant, talented, promising young woman who happened to be gay, raised in the public schools in Alabama, and she took her own life a few years ago, despite having a loving and accepting family and friends around her. But she suffered the consequences and depression that often accompanies the stigma that the broader community and the schools brought. So our family knows firsthand that there is an impact to all that negative pressure that we put. And when we codify that in law, it's all the more real to these kids.
It absolutely is. And in stories like the one you just shared, Tyler, it's devastating to me to hear the stories. Look, growing up presents plenty of challenges, right? In the best of circumstances. To see a young person in such despair that he or she would take their own life, it is, I think, as bad as it gets. And to see us with statutes that we know increase the likelihood of this happening, I think is terrible. And that had a lot to do with my personal motivation to see that we strike down the statute in South Carolina.
Tell me too that I'm sure it has we know it has an impact on the students, all students. What impact was it having on the teachers? First of all, as I've shared with you, I've known teachers, gay teachers, who've had violence acted upon them. And to not be able to be themselves in their place of employment, among their colleagues, and to be stigmatized as teachers, what kind of impact do these statutes in South Carolina?
Yeah, I'll give you a couple of examples. You used the example there of a LGBTQ teacher. That teacher, unfortunately, is not helped by our victory here in South Carolina in the sense of anything he or she can do about living their full life at work, being completely themselves at work. But the impact it had on that teacher and every straight teacher as well is the inability to help a kid. Even though many of the statutes limited the gag rule on same-sex relationships and discussions of them to the health context, they had a bleed-over effect. Utah had an explicit prohibition on this discussion across any curriculum. South Carolina's was limited to comprehensive health education. But there's a bleed-over factor. When a teacher hears a kid being bullied in the hall, called a faggot, pushed around, dyke, lesbian, all the epithets, a teacher's much less likely to step in and try to protect that child. One of the plaintiffs in our case was a kid who was routinely bullied, faggot, made fun of his supposed anatomy. I mean, just horrific behavior. A child being held down in a classroom with a teacher witnessing being wiped with Clorox wipes, saying, and a kid telling him that the road to hell is paved in rainbow colors, and wiping him with Clorox because he was dirty. This is the type of thing that happens. It happens in all degrees, not all that extreme and that vulgar, but it happens systemically. So to tell a teacher that you cannot help a child, or to suggest to a teacher at least that you cannot help a child or intervene, is extraordinary. Teachers would come to us as lawyers taking this cause on, come to the superintendent of education here in South Carolina, a statewide elected official, and to their own district superintendents and complain about the statute. Of course, they're powerless to do anything about it other than either have it struck down by a court as unconstitutional, or to have the General Assembly revoke it. So the limitation on a teacher's ability to help a kid is extraordinary. And that's, I think, one of the most important benefits of striking this statute now.
Well, so tell us about the case and how you came to be involved with it.
I had just a little bit of personal information. I'm a gay guy. I'm a dad. I've got 4 kids. I was married for 20 plus years to a wonderful, wonderful woman who is still my dear friend. So I've watched kids grow up. I've been a dad helping kids grow up. I've seen kids that were LGBTQ be harassed, friends of my children. And I always had, unbeknownst to many, because I wasn't out, a sore in place in my heart to see this going on. And I remembered what it felt like to sit in classrooms as a kid when I wasn't sure who I was. and to hear these types of epithets, and to see teachers unable or unwilling to really intervene. So it was always an issue that bothered me. I wanted to take it on, didn't know how to do it. And I'm not a constitutional lawyer per se. I've handled a variety of cases involving constitutional issues, but it's not what I do all day, every day. And began to build a team of lawyers here in South Carolina, and within my law firm, Womble Bond Dickinson, you and I happen to be partners in the same law firm, who said, look, let's commit ourselves to becoming excellent in this subject matter, and mastering the subject matter. And then began to work with South Carolina Equality, which is our leading statewide LGBTQ equality organization. And then began to branch out and work with organizations in other states, including a couple of national organizations that are tremendously talented, Lambda Legal, and the National Center for Lesbian Rights, and then also an organization called the Campaign for Southern Equality out of Asheville. All tremendously talented folks, and really good people who do a great job. And we put a team together. I assembled that team. I built that team. I was the only South Carolina licensed lawyer that was going to be in the fray. And we certainly evaluated the law, analyzed the law. We knew pretty early on how we were going to attack it from an equal protection perspective. We did a lot of work vetting plaintiffs, identifying and vetting potential plaintiffs. You can imagine when most of the healthcare at issue, health education at issue here in South Carolina takes place in 9th grade. If you want injunctive relief, you're going to have a kid who's younger than that. Well, you don't just walk up to an 8th grader or 7th grader who you think is gay or might be gay and ask them if they'd like to be a plaintiff in a lawsuit. This is an incredibly difficult position for a young person and certainly their families. And so we worked through South Carolina Equality and a number of other LGBTQ organizations, Campaign for Southern Equality, of course, as well, which I mentioned, and ultimately had a couple of families step forward and say, we think this is important and we want to take this on. So that's how I came to it and how we assembled a team.
Well, so this case didn't quite take the pathway that a lot of folks would have expected. You were able actually to procure some cooperation from the government officials, it sounds like. Tell us a bit about that.
Yeah, absolutely. Our expectation, certainly my expectation, was that we would litigate this case to conclusion, including appeals through the courts. That would be what the history books would tell you happens in South Carolina when you challenge an unpopular, a popular statute or a statute that gives effect to historic bias. The civil rights era would tell you that, and unfortunately, some of our recent history would suggest that as well. So our expectation was we're going to be in a multi-year fight, and we geared up for that. Just prior to filing the suit, our anticipated filing date, I had discussion with the attorney general here, a gentleman by the name of Alan Wilson. He's a Republican attorney general, has served multiple terms. Alan, and I'll call him by his first name, is a friend, a person I've known for many years. I've worked with on a variety of political issues in Republican circles. A very fine lawyer, very fine individual. I thought that the political circumstances would prevent Alan from doing anything other than defending the statute vigorously. Molly Spearman, the superintendent of education, a former teacher, a former member of the General Assembly, a statewide elected superintendent of education, a wonderful person, a mother. She also, I thought, would be extraordinarily limited and unwilling, I thought, to give a different approach thought. I didn't think the politics would permit it. But to their credit, both of their credit, through a series of discussions, we ultimately found a better path. And what happened was the superintendent had long been bothered by the statute. The superintendent requested an advisory opinion, as she can do under the law as an elected official, the Attorney General as to the constitutionality of the statute. A brave request on her part. Just as brave in reply, the Attorney General and his very talented staff, including the Solicitor General, a gentleman by the name of Bob Cook, they replied to the request for an advisory opinion. And they opined that based on the law, as it had changed so much in the last 25 years in America, that this statute violated the Equal Protection Clause of the United States Constitution by discriminating against a class of individuals, LGBT students. The Attorney General, in about 15-page opinion, gave a thorough consideration and analysis to the question and concluded what I think most scholars and most lawyers fairly reading the statute and the case law would also conclude. To his credit, he was brave enough to answer her question. He didn't have to. And he was brave enough to leave the politics aside and answer the question straight up. And so at that point, we knew that we were still going to pursue the litigation because that wasn't going to get rid of the statute or render it a nullity. But we thought it was incredibly helpful and important that the state's chief law enforcement officer and the state superintendent of education requested advisory opinion and said publicly that she agreed with the holding and the findings of the advisory opinion. That was a big step. So we filed our lawsuit and almost simultaneously we're negotiating a judgment and consent decree that would strike the statute down and have it rendered unenforceable.
And who had to agree to the consent there? Who's the case defendant in this instance?
The case was styled against the superintendent of education. I will tell you, it bothered me, and we joked and teased about it, that we had to name the superintendent of education. There's no other way. The statutes in South Carolina and our Constitution charge the superintendent with the enforcement obligations of the Comprehensive Education Act. And so that was our defendant, obviously in her official capacity only. And we went to great lengths to make sure people understood that at every turn. So the consent decree was negotiated with the superintendent and through her very capable general counsel, a woman named Kathy Hazelwood, who was extraordinary. And we negotiated the terms of that. Our case had been filed in Charleston, South Carolina. Judge Norton had the case.
In state
Judge
court?
Federal district court in Charleston.
Yeah.
And Judge Norton understood the constitutional importance of the case, the significance of the issue, and really facilitated the parties, we as plaintiffs and the superintendent of education, finding resolution through a consent order and judgment. And so again, I applaud the court as well for really creating an environment where the parties can work well together to try to find resolution, and we did.
So the judge issued an order on the negotiated outcome in March.
That's correct.
So,
absolutely.
So what's the substance of that order? What's the impact?
Yeah, here's the substance. The order declares South Carolina's no promo homo or anti-LGBT curriculum law. That's my preferred lingo for these types of provisions. It struck it down, said it was unconstitutional. It violated the Equal Protection Clause. It largely tracked the reasoning and the analysis of the Attorney General, the South Carolina Attorney General's opinion. And it would have tracked exactly what we would have been arguing in motions and in briefing to the court. The law here, we were all in agreement with and understood. And, federal judges don't just declare laws unconstitutional willy-nilly, right? When you strike a law from the books rather than repeal it by the actions of elected officials, it's critically important that it be right. And so Judge Norton was very rigorous in his requirements that this be fully briefed and analyzed. He obviously concurred with what the parties had concluded. and gave it effect of the court, of the judicial branch of government, by entry of the order. Importantly, this is the first litigated conclusion with regard to one of these statutes. The two other statutes that have been struck down in recent years weren't struck down by legal action. This is in Utah and Arizona. In both instances, a lawsuit was filed on similar grounds, equal protection, and sometimes there was a First Amendment or some other federal statutory grounds. But in both of those situations, the General Assemblies of those states in Utah and in Arizona repealed the statutes. Literally within weeks or months of the lawsuits being filed in federal court in those jurisdictions, the General Assemblies of those states, the legislatures acted and repealed the statutes. We did not go immediately to the General Assembly after we filed the lawsuit, and instead worked through a process with our adversaries there to come to conclusion. But it's important because it's precedent in other cases.
And this is a more permanent solution, right? I mean, a repealed law a new law can always be passed. Now we know that this is, at least in the district in South Carolina, the courts there consider this unconstitutional. They won't pass another law that would accomplish the same.
That's exactly right. And it's also instructive to federal judges who ultimately will hear challenges in other states. When lawyers go to Alabama, and we will, to challenge that statute, a federal judge there will be able to look at Judge Norton's order, at the briefing surrounding that, and obviously conduct his or her own analysis based on the briefing of the parties there. But there will be a precedent for a federal judge striking the Alabama statute or the Louisiana statute or other statutes that are similar. And so that's very important. When we were preparing to file suit here, and I just glanced to my right, I'm looking at the South Carolina General Assembly right out my window here. Our state capitol is up my window here to the right. We didn't have any authority we could cite specific to these 8 states and these provisions because no court had taken it up. So it's an important step forward in the jurisprudence that hopefully will make challenges in other states quicker and more likely to be successful.
And just a remarkable outcome. So you mentioned something interesting. You said that the state superintendent was brave to request the advisory opinion, and that the attorney general was just as brave to be willing to offer the opinion, and that they both acted bravely in the negotiated outcome. But I'm thinking about you as this very prominent political attorney in the state of South Carolina, a conservative state. I should mention that I was once a resident of Columbia, South Carolina as well before moving to Alabama. And I know that there the legislature might be a little more reluctant. It might have taken longer to pursue that solution. For you to take this up, and also as a member of the Republican Party, where there's more conservative resistance to that particular change, perhaps not at all to alleged discrimination widely in the party, but there would be some more resistance among the conservative portion of the party. It must have taken some bravery on your part to step forward to take this action.
I guess so, Todd. I'll tell you kind of how I came to it. I had been a person who came to understand their orientation later in life. Was married to a wonderful woman with wonderful children who are tremendous, absolutely tremendous. There's no finer human being on earth than my wife. I'll call her my ex-wife. I guess it's the right term. I hate the phrase. My friend, Jamie is her name. When she and I knew that we had to deal with this, we concluded that I had to own this for me, that we had to own it for our family, and that I had to own it for my children. If I moved to another state and continued my practice of law or just slipped away in the night, which many people do for completely understandable reasons, what would that do for my children, our children? And the conclusion we came to is that we were going to stand together as a family. Our family was going to change, but we were a family, and we were going to stand together. And so, knowing that your kids and your lifetime partner and friend support you, that takes a lot of the risk away, right? And then to know that I have represented and know just about every prominent Republican in the state. It's a small state. I don't say that braggadociously. It's a small state, and I've represented many folks, including the party itself. I had relationships with folks of trust for many, many, many years. I've been involved in many litigated issues, representing Republican candidates, representing causes that many Republicans would agree with, and many moderates, independents, others as well. It was an opportunity for them to see, wait a second, here's a guy I've known forever that I've always liked and trusted and respected. And now I know one more thing about him. I just happen to know that he's gay, but he's the same guy. And so, I had some trepidation and some fear. But I will tell you, the number of disappointing experience I've had related to this lawsuit and beyond this lawsuit have been few. The number of hugs, some public, some private, that I've received, and the encouragement that I've received has been extraordinary. So people are good, in my view. Look, I think we're all capable of good and bad. I do believe in original sin. I'm a Catholic guy, but I think we're capable of real good and on bad days not so good. What I've experienced is mostly good, and I hope in some ways that will make somebody else a little less afraid. I think for a young person in a classroom, the statute and its defeat hopefully will make a kid a little less afraid, make a teacher less afraid, make a teacher willing to step in. I described a kid being wiped with Clorox and wipes, and kids calling him homophobic epithets. I don't think for a minute, I pray not for a minute, a teacher would stand by were those racial epithets. And yet somehow this statute in our history together prevents so many teachers from standing up and stepping in. I hope that'll change. I don't know, brave, I guess, but I feel really honestly more grateful to have had the opportunity, and that my life circumstances would empower me to be able to bring this case and to present it in a way to elected officials that didn't lend itself to quick caricature or ridicule or marginalization, and allowed them to see the right conclusion and to be brave themselves in response to the lawsuit. And I applaud them tremendously for that. I'm very, very proud of Alan Wilson. I'm very, very proud of Molly Spearman. I think we don't always agree on everything. There's things from a policy perspective with which I would disagree with both of them. But they're properly motivated, capable, honorable public servants who do their best to get it right. And on this day, they got it right as well. And I applaud them for that.
So you just illustrated sort of the core point of the whole TendingBar project is that there are values and purposes that underlie law and policy. And sometimes our application of those values and principles takes the wrong turn in the way it comes out in statutes. And the purpose, the higher purpose of lawyers and the profession is to keep working to get it right. And that's not something that is owned by one political party or any particular profession, but we all have that obligation, I like to think, to keep working. And you and I are a good illustration of this. We share these values around the sacredness of each individual, certainly regardless of sexual orientation and regardless of party, even if we might be on opposite sides of the political aisle sometimes. And, I want to say how grateful I am and my family is, and I know a lot of people are, for the hard work that you've done in South Carolina and the positive impact that will have on kids and teachers and all of us for many years to come. And I want to thank you also for being part of the conversation today and sharing with us.
Todd, I appreciate it so much. Let me make one point in closing, if I might. I think it is in our partisan politics today, it's so important, in my opinion at least, for voices of LGBTQ equality to not come exclusively from a single party. We're able to talk past each other. Many Republicans, I'll give you an example. There's significant polling data in Georgia and in South Carolina. A majority of Republicans, self-identified Republicans, believe there shouldn't be discrimination against LGBT people based on their orientation or gender identity in housing, public accommodations, employment, et cetera. Many folks from other parts of the country might be shocked to know that there are Republican people here, and I'm not talking about elected officials, I'm talking about the man on the street, the woman on the street. And the polling data would suggest that's a prevailing view. Well, that doesn't reflect our history, and that doesn't reflect the state of the law in most of the South. And I think it's really, really important for Republicans to step up and to lead from within their own party, our own party. I remind people, the Republican Party was and is the party of Lincoln, the Emancipation Proclamation, the post-Civil War amendments, women's suffrage, Voting Rights Act, Civil Rights Act, Americans with Disabilities Act. The history of the Republican Party, to be over a long horizon, should be understood and should strive to be the party of equality. That is its birthright. That has not, disappointingly, always been true historically, and that's true of any organization. It's particularly not been true in recent years with regard to LGBTQ equality. And I want to be a part of changing that. So I think that's another reason I think it's important for Republicans to step forward on these issues. So I'll leave you with that. That came to me as you were describing our shared commitment to individuals and the sacredness of every human being. And I just wanted to make that point from a Republican perspective. And I think there's a unique need and opportunity to try to affect change from this side of the aisle.
Well, Kevin, thanks for joining us today, and thank all of you for joining and listening in. I think we all have a debt of gratitude to Kevin and the whole team that worked with him, both in South Carolina and around the country, as they demonstrate the kind of values that the profession stands for, and exactly why we are doing this TendingBar project. I hope you've drawn some encouragement from our conversation today, and we hope that you'll join us back here for our next episode on TendingBar. Thanks very much.